you're going to wait until ready to seating the jury, which is probably a 2-week process in this case, and then figure out, hey, we can't seat a jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to seat a jury? It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the voir dire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process. At a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process. At a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that, and then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of a double step to figure out if it was necessary. I've been struggling with this, for 12 months. And so it's hard to know. Now, that doesn't mean that one of the parties can't present evidence. And the standard is kind of squishy, in my opinion. But the parties can't present evidence. And the standard is kind of squishy, in my opinion. But they can provide that kind of information well before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information Mr. Koberger is going to present. So now I'm scratching my head about, is May, first week of May, does that allow enough time? Does that allow enough time for you, Ms. Taylor?
Your Honor, I think it does. I can present the information to the state. I can have my briefing, and I can have affidavits and let them know of any witness that I want to call. I can do that probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Thank you. Ms. Beatty, what are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to as far as the timing of the hearing compared to the timing of trial. But as far as a briefing schedule prior to the hearing itself, that timeline makes sense to the state.
Well, let's explore that just for a moment, because I've been thinking about setting a trial. Also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson in our last hearing, and it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so far away. Now, it's not just, doesn't just affect Mr. Koberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, about when we could really be ready for trial. Now we want to do it once. Okay. So let me go first to you, Mr. Thompson, about when. I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab. We've got Moscow Police Department, Latah County, Pullman Law Enforcement, Pennsylvania Law Enforcement. And I think you mentioned it's hard to get all this stuff together. And that is one of the things that has delayed setting the trial. And that is one of the things that has delayed setting the trial. And that is one of the things that has delayed setting the trial. Not to mention the motions about the grand jury procedures, also the issues about the investigative phonetic genealogy issues. And I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
Judge, most current projection that we have would probably be at the end of this summer. The majority of the discovery has been provided. That's not to say that Mr. Koberger has been able to, and his defense team been able to digest it all, because it is substantial as an understatement. We are still awaiting information that the defense both wants and needs to have, and we're going back through all the discovery to make sure that nothing's been overlooked. We have 2 members of our team, an attorney and a legal assistant, who are essentially assigned full time to that task. And that's projected we got from them. It could be up to 6 months, which would put us with initial discovery completion at the end of August, 1st of September of this year.
Because last time you were talking about August for the trial. Because last time you were talking about August for the trial. Because last time you were talking about August for the trial.
Sure enough. And that's what we had hoped for. And when we filed our motion for trial setting scheduler back in December a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated that just on the death penalty alone, they will be filing multiple motions, and they've been very lengthy. We've seen the same filings in the Nez Perce County homicide case that recently resolved. Those I could see taking a couple months in and of themselves to address, in addition to motions that actually directly relate to the merits of this trial, discovery, motions of limine, and that sort of thing. Our team met again this morning with our companions from the AG's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you say anything about that. Yes, I was looking at whether or not it was realistic and fair. Okay, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my pad here, March 3rd, 2025 for trial.
Okay, I had no idea. I wasn't reading your mind or anything, but okay, I had no idea. I wasn't reading your mind or anything, but okay, I had no idea. I wasn't reading your mind or anything, but I thought that's about the mid, and I remember, Ms. Taylor, that you said that would be the soonest you could be ready.
And that was if everything went right from that point.
And I remember that.
And it hasn't. It hasn't. But I'll hear what their proposals are.
Okay. Go ahead, Mr. Thompson.
Thank you, Judge. So we would propose that the court set March 3rd of 2025 as the start of trial. We would propose a September 6th, 2024 preliminary discovery deadline that would include exhibits known at that time. November 8th, 2024 for the defendant's discovery deadline. That would give them a chance to respond to any last-minute discovery that comes out from the state. February 7th of 2025